The High Court has given the Political Parties Act a lifeline after a three-judge bench dismissed a petition seeking the suspension of the operationalization of the Political Parties Amendment Act 2022 over constitutionality questions. Now, the three-judge bench, comprising Judges Hedwig Ongudi, Esther Maina and Daniel Ogembo, also dismissed the petitioner's claim that there wasn't sufficient public participation. Now, the judges, however, found two sections of the law unconstitutional, giving the petitioner partial victory. Let's get more from our very own Chemtai Gowi.
It was a big win for the Azimio One Kenya coalition political party as the High Court threw out a petition proposing the suspension of the implementation of provisions of the Political Parties Act 2022, which birthed the coalition party by changing the definition of a political party to coalition political party.
It is big because Azimio, as you know, is a coalition political party. And therefore, the question of how would you define a political party and the question of, those questions were very, very important for Azimio. The question of inclusivity, etc., and participation, which has been preserved. Was very, very important for Azimio.
The petitioners Salesio Mutuma Thuranira, Katiba Institute, AfriCorg, ICJ Kenya chapter, and the Kenya Human Rights Commission wanted the law suspended, arguing that it negated the political rights of Kenyans, the rights of political parties, and that some of its proposals interfered with the independence of the IEBC.
The impugned amendments do not render the principal Political Parties Act ambiguous, uncertain or vague.
The bench further dismissing the assertion that public participation was not sufficient, noting that the generation of the bill commenced in 2017 before the subsequent debate and eventual approval in Parliament.
We find that the public participation that took place before the enactment of the impugned amendment was consultative, meaningful and reasonable. The amendments cannot therefore be nullified on this ground.
All was, however, not lost for the petitioners. The judges found that two sections of the Act were unconstitutional, including an amendment the court noted created a conflict between the role of IEBC and the registrar of political parties in the regulation and monitoring of nominations of political parties.
One is Section 31, 1A, that had the effect of exempting political or other coalition parties from audit from the Auditor General, because coalition parties are also funded by taxpayers' money, so there wasn't any reason as to why they were exempted.
The Political Parties Act introduces a raft of provisions crucial in strengthening the management of political parties, thereby enhancing democracy. For the Political Parties Act was touted as one to bring sanity to political parties, help grow them and entrench the rights of individual political parties within a coalition. The petitioner in this case is dissatisfied with the decision of the High Court and says they will be moving to the appeals court to challenge specific rulings. Chemtai Gowi, Citizen TV, Milimani Courts, Nairobi.